Good evening, this is John Milburn, part of the Environmental Law series. We're into week 9. Tonight we're dealing with civil law. What we're really looking at is the procedure for getting into court, into the Planning and Environment Court, and looking at some of the rules that apply in that jurisdiction. Before we do, I'm going to share with you the screen and tell you about the Queensland Legislation Handbook. This is pretty old, but it might be a useful resource to keep up your sleeve. The Legislation Handbook provides some good commentary in relation to the way in which legislation comes into existence, but in the context of the policies underneath it. So it talks about the drafting process, talks about the parliamentary process, subordinate legislation, and it talks about the way in which, in essence, the policy behind law becomes law. Now that might be useful if you're looking at mounting arguments in relation to certain things. You can go back to the Legislation Handbook and it will provide you with some arguments that might be useful to advance. The interesting part from an executive perspective is the subordinate legislation, so keep that in mind as well. All right, so I'm going to now stop the share and we'll talk about tonight's discussion, civil law. Before we do you have any questions that you want to ask? It can be about anything. Any comments? Yes, Jace?
I just wanted to know if I don't know how well you've done with assessments, but overall, if you know how well we've done as a whole group.
Pretty good. There's a bit of a mixed bag, but overall pretty good. And what I plan to do is release the assessments for 11046 on probably Sunday. And the way in which I'll present the feedback is an audio talk, only for about 3 minutes. And I'll give you your grade, I'll break down the grades and I'll compare that to the class averages. But overall, good. What I really like is the presentation. At the start, you've got to convince me that you're serious, and that means presenting the work in a good manner, a professional manner, and footnote referencing. And then I think, all right, well, this person knows what they're talking about, and I'm encouraged to read more. I mean, that's just the starting point, but the actual content overall has been very good. I should warn you, I'm a pretty hard marker though, so just keep that in mind. Thanks, Jace. Any other questions? Yes, Jace?
Was there anything that specifically we were really bad at generally, like as a whole group, or not really?
I'll give you some feedback once we've, as a whole, once all the papers are in. So, but I won't do that at the moment. But generally, no, I'm really happy with the work. It's been great. Thank you.
Yes, I've been finding your assignments difficult with the footnotes and everything, and trying to reference essentially passages, like particularly from cases where you have to quote the facts, and it's hard not to seem like you're plagiarizing. I mean, because you have to write the facts. You can't. It's really hard to write the facts in your own words. You know.
Look, and that's right. And you can, provided you footnote reference, provided you reference your material, you're fine. You can, introduce direct quotes, and it's a good way of doing it. Okay.
I have found that particularly with the next assignment that the word count is a problem. Like, I'm finding it really difficult to get, below the word count. There's so much shit you got to write to try and summarise all these government websites and the process of things. That the footnotes, I mean, if you can stick some stuff in there, I mean, it's one way to get through it. But
yeah,
I mean, I'm finding it hard to write. Well, I ask you this. With that assignment, 1,500 words, the marks have been allocated per question. Is it like 5 marks out of whatever is 300 words? Is that sort of roughly how you look at it?
Well, I suppose you could do that. I always try to be too prescriptive in terms of allocating marks for certain things. And the reason is that I encourage people to be creative, to argue different ways. And the way you approach a problem may be different to the way I'd approach it. So if you stuck with my prescription that you must, 2 marks for this concept or paragraph, it doesn't necessarily work too well. But use the footnotes. They won't count towards the word count. And also, if you go over the word count, I'm not going to be too concerned. Try not to go more than about 10% though.
Thank you.
It's still tight.
So
but
if you go over the word, by how far? How far can you go over the word count where you won't mind?
If you go over the word count by 10%, there's really no problem. But if you go beyond that, I'll start to look at it critically, and then I'll be thinking, was this really necessary, or did you word this in an efficient manner? So you really start to become penalised if you go more than about 10% over. Sorry, that's vague, John.
Well, if you look at 5 marks out of 1,500 words, it's only 300 words for 5 marks. So that's 330 for 10%. I mean, I wrote 400 to 600 and then went, oh shit. I mean, how do I chop it down? I mean, and then I found that for the next question. And then,
No, and that's a fair point, and I appreciate that feedback, and I may need to look at that word count. I guess because this is not part of the law school, I've tried to make it less onerous than I would do if it was in the law school. But maybe sometimes in trying to make it less onerous, I actually make it harder for those sorts of reasons. But that's a really good point, John. Thank you. Okay. All right. Well, look, let's have a look at some issues to do with civil litigation. So we want to be at a stage where we can advise people about going to court. If we're going to look at this from the perspective, let's say, of challenging environmental decision making, it can either be through a merits review or it can be through judicial review. A merits review is where we're looking to have the decision considered afresh, a brand new decision, irrespective of what the original decision maker did or how they went about their process. On a merits appeal, the Planning and Environment Court will reconsider all the facts, consider them as they are at that time, and make the correct and preferable decision. Judicial review is where the court is called upon to consider whether the decision maker erred at law, bias, or took into account irrelevant considerations, had no jurisdiction to make the order, things of that nature. So just bear in mind that fundamental distinction between a merits review and a judicial review. But before you go to court, before you go to the Planning and Environment Court in Queensland, for example, you need to consider what type of action you're seeking, what type of remedy you seek, and you need to be a person who's eligible to ask for that remedy. So you need to have standing. You have to answer the question that may be posed of you at the start: do you have the right to agitate this matter? So the party's entitlement to stand before the court and argue a case is called their standing, or locus standi is the Latin. So traditionally, standing refers to a party's ability to demonstrate to a court a sufficient connection to or harm from the subject of the court proceedings. When it comes to standing, that ability to walk into court and get your foot in the door, so to speak, the rules differ between the common law and statute, and they differ in the statutory scheme between Commonwealth and state. And even within the states, they vary as well. So there are a range of rules that you need to be aware of. The nature of the relief that you seek also may have a bearing on the ability to stand before the court and ask for that order. In a Commonwealth situation, the status of the applicant might be relevant as well. So you might ask yourself, are you an individual or an organisation? And you see that that may be different. Okay, so let's have a look initially at the common law. At common law, the rules are restrictive, and the common law entitlement to standing is limited. So at common law, a litigant had to establish, if you like, a special standing or a legitimate interest. And different rules may apply in different circumstances. So at common law, you had to establish that you had a legitimate interest, otherwise the court is entitled to effectively say, why are you here? What's it got to do with you? You've got to establish for our benefit that you have some special interest in this matter, or you're affected over and above the way in which members of the general public are affected. It's a very old principle. It goes back to, days of contract and tort at the early stages to say, if you're a party to this transaction or if you're directly affected, then we'll hear you. But if you're just coming to the court out of general interest or as an academic exercise, we're not going to let you go through that process.
It's a way,
yeah. Yes, John?
To stop people legitimately protesting. That's what it is.
I think at common law...
It's arranged by the elite, the ruling classes, to stop people protesting that, you can't say that. Here's a reason why you can't say it.
Look, I think there's a bit in what you say. And at common law, certainly it was very restrictive. But if you're arguing a case for the prosecution of an environmental offence, sure, at common law, you may not be able to say that you'll suffer more than anyone else. But you might say everyone's going to suffer dramatically, so somebody's got to take up the action. And the statute has responded. So the common law courts interpreted sufficient interest as really dealing with things like property, commercial, economic interest, maybe social or cultural or political, but really they concentrated on the property, commercial, economic. You might remember back in week 2 or 3, we talked about some of those issues. So at common law, it's quite difficult to establish standing where you have to show that you suffered a loss over and above the loss suffered by others. Let's now have a look at legislation, because the story gets better as a result of legislation. And remember that environmental law is a new discipline, so a lot of the legislation we're talking about is quite recent. So the courts now look at legislation, but they do so in the context of the common law rules as well. And those rules have eased over time. And generally, as a community litigant, it's much easier now than previously was the case. I mean, so much so that in New South Wales, anybody has standing. You just simply walk in and say it's an environmental issue and you have standing automatically. I think that's a pretty enlightened approach. It doesn't apply beyond New South Wales at the moment. But regulations and authorities have been granted standing by... Yes, John? Yes, John?
But only if you've got the money. I mean, if you have a chance of losing, you're in serious trouble.
What are the laws in Queensland about costs in environmental litigation, John? Any updates?
Well, I only heard today that they were not going to award costs against litigants. That was a really chilling factor in anybody that even considered wanting to litigate, was if you lose and they want to hit you with the other side's costs as well.
Absolutely. So you can see that things are changing.
But not really. These developments still get put through. So, litigants go through the hell, and they're usually really underfunded against several barristers from the other side that get it done. Every case, every development, as far as I'm concerned, should have an expert, independent, legal team of experts, of barristers like yourself, that know the law, and plus the scientific panel of the physical, chemical and biological sciences to back it up, that in every development case is representing the environment. It should happen in every case. And unless you can prove that you're not going to damage the environment with this development, it's not approved. under the EPBCA and everything else that says you can't do it in this area. You can't in the Ramsar area. You can't, you know, you can't do it. I mean, they still do it. And pretty much everything's powerless to stop it. 2%, according to your friend this afternoon when I watched the lecture on the EDO, 2% of developments a lot knocked back. 2%. I mean, in some of the most pristine environments, 2%. I mean, so the environmental movement is losing. The law is losing.
Okay. Now, thanks, John. And over the next few weeks, what we do is hope to provide you with some tools so that you can deal with those sorts of issues. For example, have a look at, if you've got your legislation handy, have a look at Section 505 of the Environmental Protection Act. I'll see if I can call it up on the screen. And you might recall last week we talked about the case of, I think, Crowther against the BCC, which was the case in relation to issues to do with TAFE College. So I'll just share the screen now. You should see the other screen, and you'll see a note there in relation to Section 505 of the Act and the restraint of contraventions. So a proceeding may be brought in court for an order to remedy or restrain an offence against the Act or threatened or anticipated offence against the Act by a number of people. This is the standing part, and the minister, the administering authority, or someone whose interests are affected by the subject matter of the proceeding, and that's more the common law test. But you'll see that under the EPA, it's now been extended, and standing is available in, if you look at 1D, to someone else with the leave of the court, even though they don't have a proprietary, material, financial or special interest in the subject matter of the proceedings. And the case that we looked at last week in that regard was Crowther against the Brisbane City Council. And in Crowther's case, you'll recall that the agitator, Dr. Crowther in that instance, brought proceedings to restrain the TAFE College in relation to what was being done. And the court held that had they been merely interested as a result of a mere intellectual emotional concern, that wouldn't have been sufficient. However, they went further, and they were happy to hear Dr. Crowther in that instance. Now, at a Commonwealth level, we have similar things under Section 475 of the EPBCA. You can see that an applicant seeking an injunction must satisfy the standing test, and an applicant applying for judicial review must also satisfy the standing test under Section 487 of the EPBA. In your notes, you would have seen a flow chart, and that flow chart looks something like this. And again, I'll share the screen. This is a pretty basic flow chart.
Something like?
Yeah, exactly. Exactly. So when I prepared this flow chart, when I prepared the flow chart, I just didn't have enough room to go as far as I'd like. So you'll see on the left-hand side that it just tails out to nothing. If I had more paper, I'd go wider. So I've got to learn how to do this. But the main thing I wanted to do was follow the state regime. So in terms of standing, firstly, we look to ask the question, does it the common law or statutory provisions? And if it's statutory, we look down the right-hand side, is it federal or state? And I was mostly interested in the state provisions, which is what we're getting to now. So I mentioned that the nature of the proceedings that you intend to bring is relevant in terms of the issue of standing. So if you're seeking a declaration about a certain matter, then you have an entitlement to be heard, Section 456 of the Sustainable Planning Act. And we saw that concept in the case that we reviewed as part of our first assessment. That was a 456 decision. The second one, are you applying for a merits review? A merits review, you'll recall, is where you're asking the court to essentially redo the decision from scratch. You have the entitlement to be heard if you're the applicant for the proposed development and you're not happy. That's 461 of the Sustainable Planning Act. Or you can be heard if you're a submitter to an impact assessable development, if you're an objector. So the key there is that in order to ask for a merits review in relation to a development and you're not the developer, then you must be a submitter. And you become a submitter by putting in your objection notice. And you must be a submitter to an assessable development, and that assessable development must be an impact assessable development. So to follow up on what John was saying, there are limits. Even if you want to object to a development, you can only do so in those specific circumstances. That's if you want a merits review. If we look further along and you're applying for an enforcement order, then you have an entitlement to be heard under Section 601 of the Sustainable Planning Act. And you'll recall that in our assessment, the subject case was not only a declaration case involving Section 456, but it was also an enforcement order case seeking the interim and permanent orders available under 603 and 604. And finally, it may be a prosecution case. So if you're seeking to prosecute a person for a development offence in the magistrate's court, then again you have an entitlement to be heard, Section 597 of the Sustainable Planning Act. Now the good news is that just as soon as we learn all these things, we know that the Planning Act is just around the corner, so all of these things will become soon obsolete, but you will need to understand and know the concept behind the issue of standing. The reason I'm stressing standing is that you don't want to find yourself in a situation where you are encouraging people to issue proceedings or do something that they just don't have the right to do. And in this course, I'm not teaching as though you are going to be practicing in law, but I suspect that you will be involved in some form of legal practice, or you'll need to identify legal issues to the point where you may then instruct legal advisors or advocates. But you've got to know some of these basics. Yes, John?
Sorry, John. I think the sort of people that are in this course are more likely to be arguing for saving some type of environmental asset and trying to find some way that the developers that navigate around all these laws and still get their development done, that somehow it can be stopped. I mean, it seems like there's not too many avenues to stop developments.
Well,
no matter what the whole environment's governed by law, and yet there seems to be no way to stop developments.
Well, you know, if I could sort of just take the opposite view for a moment, what we've learned by looking at Crowther's case last week is that you can apply for an injunction. We've looked at the ability for a party to seek a declaration in relation to an environmental issue. That's under 456. Under 601, if you've got standing, you can seek an enforcement order. You can seek prosecution by showing standing under Section 597, or you can apply for a merits review if you're a submitter in an impact assessable development. So I guess the first point is this.
Sorry, John, I just want to say, sorry, that was very succinct put, and that's a beautiful exam answer.
Just the right amount of words. So look, if I can give you a bit of an exam hint, I'm always interested to see whether you can determine the threshold issue of how do you get this thing into court, and what are the options available to you in going to court. Okay, so we've talked about merits reviews versus judicial review. I think we know what they are. And I'll ask this, what matters does the Planning and Environment Court hear? It's got its bread and butter, but what sort of matters does it hear?
appeals against the assessment manager's decision.
Yes. And what sort of hearing is that? Is it an injunction? Is it a declaration? Is it a judicial review? Is it enforcement, a prosecution, a merits review? Which one of those is it?
It's a merits review.
Spot on. Very good. That's it. Merits review. So now we know the sort of thing is a merits review where you're looking to challenge a decision on a development application. It's got to be impact assessable development, and you understand that you've got to have standing to get yourself into court. Okay, so where do we find this planning and environment court? Where is it? Is it the magistrate's court?
Come on, one of you other two, help me out. Help me out.
All right, we'll make it a bit easier.
Base, where are you?
The planning and environment court is linked very closely to A, the magistrate's court, B, the district court, C, the Supreme Court. A, B or C? Suzanne says C, Jace says C, John
C.
All right.
C.
Wrong. District court.
Thank you.
B. So the district court judges constitute the planning and environment court judges, and they share the registry. Well, not quite share the registry, but it's district court judges that do the P&E work. Okay, so where do the district court judges sit when they're dealing with planning and environment court matters? It's a separate court, but they're district court judges. Okay, so Brisbane, and then the major centres, Southport, Maroochydore, Townsville, Cairns. In other places from time to time, one of the philosophies behind the court is to give the people in a particular area, the residents in an area, an opportunity to attend. So the matter may not proceed in Brisbane, it might be, somewhere like Maryborough. So before you proceed to go to the Planning and Environment Court, you need to be aware of its own powers and procedures. So what do we call these procedures, and where do we look to find out the rules that regulate the Planning and Environment Court? All right, let's call it up on the screen.
I know that.
You know it?
Don't worry, I know it.
So the question is, what do you call the rules that relate to the Planning and Environment Court? And I'll just share the screen now.
Isn't it under the SPA?
No.
Is it under the SPA?
The answer is, can you see that? The Planning and Environment Court rules are the rules that regulate the Planning and Environment Court. So it's kind of one of those. Yep, but it is under the SPA. Yeah, you're right.
It's under the SPA.
Yeah, you're right, John. You're right.
Thank you.
Very
I stand
good.
correct. Thank you.
You are correct, and I stand corrected. So well done. Thank you. You're absolutely right. Okay, so they're the Planning and Environment Court rules. Now, if you go into the P&E court, you need, of course, to know about their rules, and you need to know where they sit. You need to know what they do, and you need to know how you can start the proceedings and whether you have standing to do that. So having a copy of the rules, I think, would be a really useful thing to have ready for any examination that you might get, because it'll tell you some of those things and time limits and etc. Okay, so we'll stop that share.
Where do we find that again? Just Just have to know. Don't have to look. I've looked at so many of these videos of the last few weeks to realise all these exam hints that you've given and which flaming bits you've got to know to answer your exam questions, sir.
And the problem with my exam hits, it's a bit like my top 10 movies of all time. If you add them up, there's more like 100. There's, you know, so yeah, there's a lot more. There's a lot more hints than there could be possibly on the exam.
Yeah, we're only environmental science students, you know? We're only stupid environmental science students.
No, not stupid. No, you enjoy this. All right.
And seriously, I mean, to know the law, I mean, I thought about law once and thought, I can't remember that much.
Yeah. No, you're all doing fine. Okay, so the Planning and Environment Court rules, just look on the court's page and you'll find them. So the other thing is the Uniform Civil Procedure rules are relevant as well. So the main act, of course, if you're in Queensland, for the P&E Court, mostly concerned about the Sustainable Planning Act, the Sustainable Planning Regulations, and probably the Environmental Protection Act. They'd be the main pieces of legislation for you to consider. All right, so if you're going to issue...
sorry, John.
Yes, John?
One question I was going to ask you before the exam, and this may be somewhat premature, that when I did a previous online exam for another subject, where we would normally expect an invigilated exam to last 2 to 3 hours, this particular online exam took something like 10 to 12 hours to do the business, to do a proper job. Now, I would ask you, as the bloke that's done it, do we expect to be able to answer this exam in a normal invigilated exam, or do we expect to have to take something like the 30 hours that's been allowed for it?
Somewhere between the two. The exam I've said for 11046 is tough. It's
yeah, well, thanks very bloody much. Yeah, that's useless.
you won't be able to do it in 3 hours. I would...
Won't be able to do it in 3 hours?
No.
Okay.
Look, I would suggest if you gave yourself 5 hours, you should be fine. If you gave yourself 8 hours, you're probably spending too much time on it. But it's a tough one. I'm sorry. Each year, depending.
I know there were students in that previous online exam that, because of their laziness or poor time that they have because they have other lives, they actually have a life, that they weren't able to devote to the exam the amount of time, and so like they've logged on a few hours before the cutoff and realise that, oh shit, I can't get this done. I mean, so that is why I asked, because if it's a sort of exam, I mean, in an invigilated exam, I mean, there's only so much you can expect it to be done. I mean, if in an online 30-hour exam, how much are you can actually expected to be done?
And look, perhaps part of the advice I'd give is, if you've got the luxury of some extra time, don't rush it and enjoy the process. I mean, really, what we're aiming to do is have fun, and I really mean that, and I really want you to enjoy the process. It is fun to learn, and I
love being able to answer questions and I know, but it's when you get a question that's a bit, you know, and you've got to go and you end up going to bloody Google and Wikipedia even to try and find answers to questions that you think, oh, you know, what do they want? What do you want?
Yeah, but one of the good things about having a difficult exam question is that you can't possibly answer it in the word count completely. So you've got plenty of opportunities to pick up points, even though you may not follow the exact template that, for example, I come up with. I know that John has this publication, but if you don't have that, I would recommend that you consider getting it. It's from the Environmental Protection Defender's Office. It's about $50, I think. So it's an extra outlay. I appreciate that. But the Community Litigants Handbook is really good in that it provides you with a step-by-step basis for instituting proceedings in the P&E court. So it'll tell you.
I've found one reference for it so far in the definition of a accessible development, which I thought I'd chuck into the first assignment just because it was another reference about accessible development.
Okay.
But you believe that's a useful thing for the exam, do you, sir?
Potentially, yeah, potentially. But I can't say it's not directly relevant, but it's a good resource. Okay, so when we're instituting proceedings in the P&E court, we start by filing a notice of appeal. The notice of appeal is a pretty straightforward document. With any luck, I can call that up. Just remember there are strict time limits in the Planning and Environment Court, and you've got to be careful to comply with those time limits. So here is the notice of appeal. Pretty basic document. What you do is set out the grounds of the appeal, saying what each of the grounds in which it's alleged the decision appealed from is wrong, and it then specifies some of the dates that you need to follow. So these documents are all available on the court's website, and I'd recommend that you look at the website for that type of information. Then, of course, once you've filed it, you serve it, and you serve it on the Chief Executive of the Department of Infrastructure, Local Government and Planning. And if I haven't mentioned already, that's always a good resource in terms of dealing with issues to do with compliance or enforcement. So we had a bit of enforcement issue in that first assignment, issues to do with town planning generally and policy guidelines, dealing with applications that don't conform with the planning scheme. There's some guidelines there as well on the Chief Executive of the Department of Infrastructure website. Okay, so you serve the department, you serve the assessment manager, which is usually the council, we know that. Any referral agency or concurrence agency, but referral agency I think we call them now, usually a state government agency. And if you're an objector, a submitter, serve the application or the appeal notice on the developer. So then you apply for what's called a directions order. So if you go to court, a lot of the running is with you, and you have to apply for a directions order. A directions order means that you attend a directions hearing, and at the directions hearing, the expectation is that you step out between the parties, the various steps for them to take, and a timetable. Because the nature of planning and environment litigation is such that the intention is it moves quickly, it doesn't drag along. So we want a timetable quickly, we want all these timetables to move along. And invariably, the court will ask for a dispute resolution plan. So the process of alternative dispute resolution is really important in environmental law, planning and environment law, and these are without prejudice conferences, typically that are chaired by the ADR registrar or somebody else involved in dispute resolution. And when you're attending the conference, there are some things that you need to consider. It's always useful to try and have a draft of an order available so that you've got something that you can propose at that stage, and make sure that you've thought through the various issues that are under consideration. So once you've gone through the dispute resolution phase, you then have what's called a review hearing and a call-over hearing. So these are all basic steps in that process. And leading up to that, following that, we have the actual hearing itself. And by that stage, you're really getting to the point where you've prepared for the full trial. Look, I'll just give you some information about the ADR process. I'll just share the screen, and you'll see on the Queensland Court's website, advice to practitioners in relation to the ADR process. So that's courts.qld.gov.au, Courts Planning and Environment Court Advice for Practitioners. So you can book it, you can go to the calendar online, can request an adjournment or a review, and proceed from there. It's also got here the practice directions in relation to each of those things. All right. There's a lot more material in the study guide than what I've covered tonight, but they're the main points to get you into court, and the main issues to think about before you go to court. I think that you'll find yourself in a situation, if you're practicing in this area in environmental science, where people will look to you for guidance as to where do we go from here. Sure, we see something that we don't like, somebody's not doing the right thing. The question for you is, what do you do when the Chief Executive Officer knocks on your door and says, all right, you're an environmental scientist, you know something about the law. Where do we go? What's the first step? So you need to know that first step. You don't need to know how to run the full trial, but you need to be able to say, this is the process, this is the court that we need to go to, here's the basic procedure. We'll let the lawyers fill in the detail, but I can be the go-between between our organisation and the lawyers, because I know enough about it so that we continue to run the process. We get the lawyers working for us rather than the other way around. Does that make sense? That's really the aim.
Yes,
if you can reach that stage, that'd be good.
As long as you can pay the lawyers.
Well, that's true. That's true. But, you know, John, you might be working for a mining company. You might be on the other side providing environmental advice.
Yeah, and then, of course, they've got the money to pay for a team of barristers.
Yes, but you might be in charge of...
the person that objects to try and get a pro bono cheap lawyer.
Maybe, yep.
You know, to try and fight the same case. Like your colleague at the EDO saying, going into battle with a knife against guns.
Yes. Yeah, there is that feeling. I understand. All right. So, look, are there any questions?
It's not just a feeling. It's like environmental law is set up for developers to get around. And so developments get done. I mean, everything's set up in the environment departments in the Department of Energy. It's like, the coordinator general is in the Department of State Development, who decides terms of reference, the EIS and everything else, and says, yeah, that's okay. We want development. It's jobs and growth.
I know. But John, what I hope is that by the end of the course, we've only got a few weeks left, but by the end of the course, I hope that you'll say, okay, now at least it's a bit more balanced. Now I know the procedure a bit more. In the last week, we'll deal with a case where someone did take on a situation and succeeded, a bit like the Crowther decision. All right. Well, I'm going to ask a favour, and that is, probably by now you've noticed the big red button on the left-hand side of the screen. Have your say. It's really important for the university that we do get feedback. It's really important for me that we get feedback. So please take 5 minutes and lodge your comments, good or bad, on
yes. I would say now that this subject is probably the most relevant and the most useful to any environmental science student, that more so than any other subject in the course, because of what it does. However, the more you learn, the more you realise that it's like pissing in the wind.
No, we'll be right. We'll get there.
There must be legislated a team of environmental legal experts with a team of experts on the environment that represent the environment in every case, And if there's environmental damage, it's not approved. I mean, we're dying.
We make
Seriously.
it to that stage.
I mean, somebody like you said, so educated and so up on the law. I mean, it is in all of us that if you can do something, you have to do it. But those of us that have no power and no money can do very little.
Oh, we'll get there, and it may be at some stage in the future the government does provide funding along the lines of what you say. I spent some time last week in the mental health court, and that's an entirely different jurisdiction. It's part of the Supreme Court, but it struck me there's a similarity in that we're dealing with wider community issues, and in that court there is funding for the departments, the chief psychiatrist. Legal aid provide free representation for participants. So there is a model, if you like, and the procedures move quickly. So I know it's a bit of a stretch, but there is a model for that type of scheme where everything is funded and it moves quickly as well. All right. Well, thank you very much.
I don't understand how the environment is, the legal side is not funded. I mean, it's designed to get around it, so developments happen. I mean, it's hard to argue anything else. I mean, because they happen, no matter what Ramsar areas or World Heritage areas and make us look bad internationally and all that embarrassing stuff, mate, they still happen.
No, fair point. All right. Well, look, thank you very much for your patience. Good luck with your second assessment, which is due, I think, for 11046 very soon, and for 19038, that's pretty soon too. All the best. We'll call it a night. We'll see you next week. Bye for now.
Good luck with reading my assignment.
It'll be fine.
Bye.
See ya.